see your stream well.
Okay, 1 second. All right, can you see the slideshow?
Yes, we can see.
All right, very good. Really briefly, what is it that construction clients want? They want to make a profit. They want to complete projects as efficiently and expeditiously as possible. They want to maintain good business relationships, and they seek fairness, efficiency, and certainty in the handling of conflict. Now, in the United States, I'm speaking on US perspectives here on construction conflict management. As I mentioned before, litigation is a part of the landscape, but a more preeminent way of adjudicating is arbitration for all of the reasons that we noted before. Here are some of the reasons that construction companies, design professionals, and owners say they use arbitration. Efficient and cost-effective dispute resolution. They want something that comports with applicable law and industry standards. They want fundamental fairness. They want to get on with business. They want a quick resolution, and they want a degree of control. These are all things to think about. Now, we talked in the last panel about the importance of choice. And we know that too much choice is as big a problem as no choice at all. But it is important to some degree to look at key choices that your client wants to make with respect to arbitration. So for example, if our primary interest is in a process that is as efficient and cost-effective as possible, we may want to consider a streamlined process. And you are seeing a number of major providers, including the American Arbitration Association and JAMS, publish expedited or streamlined procedures, both for domestic use and for international use. Obviously, there are a lot of other possibilities, using a single arbitrator, training arbitrators to be as proactive in their management of the case as possible. You heard Kevin talk about opportunities for summary resolution of disputes. This is something that right now is becoming much more of a focus in arbitration. These are all ways of trying to come to grips with and effectively manage disputes to move them forward as quickly as possible in arbitration. Another thing we've observed in American arbitration is that this is based on a survey we did of many of the leading arbitrators in the United States. There is a higher rate of settlement in recent years than there was in years previously. More likelihood that a conflict is going to be negotiated to a settlement during the arbitration, or at least before an award is rendered. And finally, there may be a concern, as we hear sometimes, about ensuring fairness and certainty. Here again, I think there are a variety of things that might be done. One issue that sometimes comes up in the United States, and not so much internationally, is the role that party-appointed arbitrators are supposed to play. Believe it or not, in the United States, party arbitrators may be partisan toward the party that appointed them. Now, this is not the case under most leading rules. However, there is some concern about this possibility. Another thing that is a feature of the US system is the notion of appellate arbitration. You can actually, in the rare cases where someone wants a second look at an arbitration award, leading providers have some form of appellate that is a second level of arbitration. Now, very early in my practice, I had the wonderful opportunity to be involved in one of the first major construction mediations in the United States. And this was back in the early 80s, about 30 years ago. And mediation has really come to the fore. And I want to talk, there are many, many topics we can discuss here, but I do want to touch briefly on mediation and why it has experienced such huge growth as an engine for resolving construction disputes. We ask a group of lawyers, what is it? What are the functions that mediation performs? Look at all of these phrases or words that reflect what mediation does. Cost savings, efficiency, giving parties a voice, coming up with better outcomes, saving money, empowering the parties to work together better. You know, I like to tell my students and practitioners that we train that you know, the law and adjudication, arbitrators and judges have to look at the legal and factual and technical issues. It's a rights-based process in arbitration or in litigation. But in mediation, we have the opportunity to go below the line, below the surface, to look at all the drivers of conflict, business and personal priorities, interests, emotions, values, things that may be really, really critical. Facilitators have special skills and special abilities to be able to work with parties, to develop trust, to develop rapport, and turn that rapport into an ability to help the parties reach a resolution. Typically, mediators are, in the United States, are masters of process as well as substance. So there may be a whole variety of things you can do in mediation in terms of process. They're very deliberate about the kinds of techniques they use. They can look for trade-offs, and they can be even-handed in their interaction. And of course, they have the opportunity to conduct private caucuses. Now, we could talk a lot about mediation approaches. We don't really have time to get into that today, but let me just say that mediation has come to the fore as the primary basis for negotiated resolution of construction disputes. In fact, a lot of U.S. lawyers don't like to negotiate without a mediator. Let me show you a couple of charts. And I'm not going to try to dwell on this in detail. You'll have an opportunity to look at it later. But what this chart demonstrates in the red portions of these columns is the impact that mediation has in achieving construction companies' business goals. And what's extraordinary about this is the wide range of things that can be accomplished with mediation. And this is a much broader range of possibilities because you have the opportunity to tailor a resolution based on party interests, as opposed to simply having a limited scope of remedies, which both courts and arbitrators have. I thought this was interesting. We asked these corporate counsel for construction and design firms, what is it that you want to put in a dispute resolution provision in a contract? There are three major components. And Trin was talking about stepped or escalation provisions in contracts. Typically, arbitration does not stand alone. It is a multi-step, multi-lane process, not necessarily linear, although that's often the way it's laid out. Notice that these corporate counsel said, we'd like to have a provision for project level settlement discussions. Right in the project, we want to have executive level meetings where we can kick the negotiation upstairs to senior management and have them resolve it if it can't be resolved on the job site. We want some kind of mediation, preferably mandatory mediation, meaning the parties are required to mediate at some point. They're required to come to the table. Although I will tell you that lawyers debate this point, and we could talk more about it if we had time. Finally, if you compare arbitration to litigation, these lawyers say when it comes to adjudication, they very much prefer arbitration as a rule. But what you see here is that this is a multifaceted set of tools for resolving conflict, and arbitration is simply one of them. What you see here is that, again, I will simply describe it, and you can look at it later. Many of these people said that their primary method for resolving conflict is project-level negotiations, because that is the best way of coming to grips with conflict and preventing it from spiraling into a legal dispute. They also have an extensive array of experience with mediation, followed by forms of arbitration. So, and not only do they have a lot of experience with those areas, but we also discovered that they had a great deal of success with project level negotiation, with getting a mediator to come in and help with negotiation and forms of arbitration. They would prefer that in general to other alternatives such as going to court. So how do we make the most of mediation? There are a whole variety of ways of mediating. If we had more time, we could talk about that. Today, preparation is more critical than ever. I have a mediation in a construction case with multiple parties coming up in early July. And the parties are sending me some materials, but to me, the most important element of the mediation is what happens before I bring them together. Because I talk with the lawyers, I learn about the history of the dispute, I learn about the personalities of the parties, and I talk to them about all aspects of the matter and how it might be resolved, and we design a mediation to address that. I use a variety of techniques, as do other mediators in the United States, in the course of resolving disputes. I may focus on process issues, and sometimes I've actually helped the parties work out a form of binding arbitration to resolve the dispute if we can't get everything mediated to a resolution. And of course, there are a variety of ways of handling individual disputes. Now, here's another chart that you can look at when you have more time. I will simply say to you that this indicates that mediation may be used at many different times. There's always a possibility for negotiation or a mediated resolution. It could be during the project. It could be after the project, but before arbitration or litigation. It could be during or even after arbitration or litigation. There's always the opportunity for using it. I want to just put this, maybe like me, some of you think graphically. I was an architect by background, and I think I still think in terms of pictures for a lot of things. But I want you to imagine a chronology of a conflict, beginning with an issue, then at some point, an issue on a job site becomes a dispute. Later on, the lawyers become involved, which itself transforms the nature of the dispute. And finally, you have, in many cases, third-party adjudication, either arbitration or litigation. Now, level of conflict. What happens to the level of conflict as we go along through these phases? The level of conflict increases tangibly with each successive phase here. Similarly, the amount of cost and time that is spent increases. Now, from the standpoint of party control and ability to affect an effective resolution, that goes down. Party control becomes less and less, and finally, relationships tend to be harmed in this way. Now, if you think about it, where does arbitration occur? That occurs way up here at the end. And arbitration is a very important element in dispute resolution because it is so effective in many cases, and often it's the only way to resolve a conflict. However, we have learned in the United States that mediation, often in some of the latter phases, will be a more effective way, a more flexible way, and a more satisfying way to disputes. I'm almost finished. The other thing to think about, though, is it's possible that you can resolve disputes in real time on the project, during the project, before disputes really take off and acquire a mind of their own, if you will. You can bring in a real-time facilitator, a mediator, a role that a number of us have played, or of course an evaluator, like a dispute review board or dispute adjudication board. This may produce resolution of a dispute, or it may actually avoid a dispute. It may actually permit the parties to resolve things. And notice, if you resolve it early, all of the costs that you avoid, all of the negative elements that you avoid. If this can be done, it is a great success. And of course, as I mentioned, in addition to real-time mediation, project mediation, on larger projects, infrastructure projects, as many of you know from World Bank projects around the world, dispute review boards or dispute boards are a very important element that can be brought to bear as well. I want to end with one more example. That's a fairly recent program. And it's really a step forward from typical stepped conflict management in the construction arena. You all know the company Intel. Intel has a very large capital construction program. They have projects all over the place. They have recently developed a custom program for dispute prevention. They bring in embedded neutrals who are engaged by the owner and general contractor, people with extensive professional construction expertise, conflict resolution experience, communication skills, etc. They develop relationships during monthly visits with a risk management team, people from the stakeholders in the project. They assess job progress and risks, and they consider appropriate options for resolving disputes that arise. Often they can help mediate a resolution, and thus far, they have never had to go above the negotiation phase. They've never had to use third-party intervention strategies other than the most basic negotiation. So here is an example of moving upstream and managing conflict at its roots. Well, I think I'm just about out of time, but I hope this has given you a sense of the multifaceted nature of dispute resolution and conflict management in the United States. Arbitration is a very critical element of it. Mediation has come to the fore. Forms of non-binding evaluation, including real-time processes, are very important. And now we have active project management as well.